So it's going to be fairly interactive, folks, and I'll be inviting questions as we go along. Now, firstly, I'll give you a definition of mediation. It's in the handout that you've all got there. Mediation has been defined as a method of dispute resolution which includes undertaking any activity for the purpose of promoting the discussion and settlement of disputes, bringing together the parties to any dispute for that purpose, and the follow-up of any matter being the subject of such discussion or settlement. An impartial third party attempts to facilitate settlement by encouraging the disputing parties to generate solutions that focus on their mutual interests and preserve ongoing relationships. Mediation may take place before or after an application has been made to court. Mediation should be conducted with as little formality and technicality and with as much expedition as possible. Generally, the rules of evidence do not apply to mediation sessions. Now, that definition comes from Butterworth's Australian Legal Dictionary. A further definition of mediation is quotations, a settlement of a dispute or controversy by setting up an independent person between two contending parties in order to aid them in their settlement of their disagreement. That's from the Fairline Online Dictionary, and the web site on point is www.encyclopedia.thefreedictionary.com. Needless to say, mediation's become very popular in the West over the last 2 decades and has some compellingly useful attributes. There is, however, a mounting body of research that is shedding an increasingly negative light on this form of dispute resolution, and I'll be dealing with some of the disquiet regarding mediation later on in this session. Now, in terms of my own lay definition of mediation, I've defined it as a process where, be it through the courts or a tribunal or a term of contract, the parties are compelled to refer their dispute to mediation. A mediator is appointed to convene a meeting that is designed to facilitate negotiation and ultimately compromise. The mediator is a facilitator, a cajoler, if you will, and has no power to compel the parties to agree upon the outcome, and I emphasise no power to compel outcome. Another useful definition of mediation is provided by Ms. Robin Carroll from a paper, Mediator Immunity in Australia, that was published in the Sydney Law Review. Mediation is a process in which the parties to a dispute, with the assistance of a neutral third party, identify the disputed issues, develop options, consider alternatives, and endeavour to reach an agreement. The mediator has no advisory or determinative role in regard to the content of the dispute or the outcome of its resolution, but may advise on or determine the process of mediation whereby resolution is attempted. Now, if the mediator is unable to engineer a settlement or an accord, then the mediation fails and resort is had to the more adversarial forms of dispute resolution like the courts, the tribunals. Mediators have to be independent and impartial, and they've got to ensure that they control the temptation or the urge to force or drive outcome. A mediator does not determine the parties' legal rights and entitlements, and therefore they should not have the same broad immunity of judicial officers. And that's from the same paper from Robin Carroll. Judicial officers, be they members of the courts, the bench, tribunals, have judicial immunity, so they cannot be effectively sued for judgments that the consumers of the judicial system take issue with. Now, typically the process of mediation goes along the following lines. Mediation might be triggered by a contract. It might be triggered by a written agreement to mediate. It might be triggered by a court requirement or a tribunal requirement. In the case of a contract, it can state that when a dispute occurs to do with the contract or any matter of contractual import, then it has to go to mediation. A well-crafted mediation clause will provide that the parties must agree upon a mediator, or in the absence of an agreement, the contract should provide that the matter must be referred to a nominating body to nominate a mediator. Ordinarily, the contract will provide that the mediator be remunerated on a 50-50 basis, but that's not necessarily without its challenges. Preeminent construction lawyer Justin Cotton, sitting to my left, was making mention, coincidentally, this morning, that there was an agreement to mediate, and it was incumbent upon both parties to pay 50-50 on a 50-50 basis the cost of the retention of the mediator, and the other side, unrepresented by a lawyer, said, I refuse to pay the 50%. Now, by virtue of the fact that there mightn't be any court mechanism to compel that payment, then that's a bit of a no man's land dynamic. If a contract says that one party is to provide 50% of the remuneration of the mediator and that party refuses, well, it's uncertain as regards how there can be a circuit-breaking situation and ultimately the retention of the mediator. The contract should also provide that the parties must meet with the mediator, and the contract will provide that a disputant invoking the mediation clause will provide a written dispute synopsis that's dispatched to the mediator and copied to the other party. The contract should also dictate that the mediator is free to conduct the mediation as he or she's fit, but the contract likewise should stipulate that if perchance there's no accord, then the mediation will be aborted pursuant to the contract, and the parties will be at liberty to refer the matter to an adversarial form of dispute resolution. Note that it's important, if you want to generate contractual efficacy or weight to the mediation clause, to ensure that the contract provides such mechanism. An example of a contract-induced mediation clause is as follows, and it's one that many years ago I prepared in conjunction with the Law Reform Commission for the Law Institute of Victoria to do with a plain English building contract. So I'll go through the terms of the clause. The mediation procedure is that if a party wishes to resolve a dispute, notice must be given to the other party and to the selected mediator, or if that mediator is not available, to a mediator appointed by the President of the Law Institute or the Law Society, whichever case it may be. The notice of dispute must state the disputes arisen and state the matters in dispute. The parties must cooperate with the mediator in an effort to give an opinion on various matters. Note that the mediator cannot provide the opinion, but can be a facilitator on point and elicit an opinion from either party, which, needless to say, cannot be, when all said and done, compelled. Each party must pay a half share of the cost of the opinion. Where an opinion is deployed, if the dispute is settled, the parties must sign a copy of the terms of settlement. Absolutely critical that if the dispute is settled, the parties crystallise the terms of settlement into a written document that's co-signed. If the dispute is not resolved in 14 days after the mediator has given notice or within any extended time, then the parties must abort the mediation. Each party must pay a half share of the cost of the mediator to the mediator. The terms of settlement are binding on the parties and override the terms of conflict. If there's any conflict, either party may commence legal proceedings when mediation ceases. The terms of settlement may be tendered in evidence in any mediation or legal proceedings. And also, very importantly, a provision along the following lines. The parties agree that written statements given to the mediator or to one another and any discussions between the parties and the mediator during the mediation period are not admissible by the recipient in any legal proceedings. I'll be talking about the possible controversy of confidentiality a little bit later, but it's important that there is a confidentiality clause in a provision that facilitates mediation. Courts increasingly over the last few years have effectively forced mediation. You've got jurisdictions, for instance, like the Victorian Civil Administrative Tribunal in Victoria, that require mediation to occur within 3 or 4 months of the initiation of a dispute. And increasingly, the courts, as distinct from the tribunals, refer a matter to mediation before the matter goes to hearing. One of the advantages with some of the tribunals is that once legal proceedings are initiated, there's a directions hearing and mediation is brought on as the first point of call, whereas in the courts often mediation doesn't occur until well down the track, often close to hearing. It's best to have a mediation front end rather than tail end. Now, take great care when it comes round to settling mediations, and the devil is often in the detail. Any mediation settlement agreement has to be comprehensive, well drafted, and must embrace all matters that gave rise to the dispute. A poorly drafted settlement agreement is open to challenge, and they are frequently challenged when one of the parties, in hindsight, thinks that the result could have been better. Another problem with the mediated outcome that occurs outside the auspices of a court or a tribunal is that its enforceability at law may be in question. It's very, very important to engage lawyers to appear at the mediation to advise upon the terms of mediation settlement and the consequence of and import of such terms. There should even be a clause in the terms of settlement along the following lines, and this is in some respects to protect the advocate who's representing the client. In settling this matter, I have agreed to do so of my own volition and free will, and understand every term and condition of the settlement agreement. I've also had the terms of settlement explained to me by a lawyer, and I'm prepared to settle the dispute on the basis of the terms herein. Now, why that sort of provision is useful is that it's not unusual for a disputant to subsequently take issue with the settlement augmented. It's a bit of a furphy that mediations are win-win. They're not. Quite often mediations can be better be characterised as lose the least.
Lose-lose?
Yeah, lose the least vis-a-vis lose the least. So it is rare for a party to come out of a mediation singing happy days, and once things settle, it's not unusual for a disputant to then take issue with the settlement and say to the lawyer, look, I'm not terribly happy with the outcome. I compromised more than I would have prepared to, and particularly in circumstances where a client might want to get a bit of a haircut on a legal bill, they can often use that sort of information. On a more sinister note, if the settlement does culminate in a situation where there is a significant compromise achieved, often in circumstances that are driven by the lawyer having formed the view that the case is manifestly devoid of merit, the lawyer needs to ensure that the owner, the disputant, owns the decision, lest down the track there's a lawsuit for negligence. Now, I'm also going to touch upon the virtues of mediation vis-a-vis the downsides of mediation. Mediation has basically been canonised over the last 20 years as being a new Butte panacea to all things pertaining to conflict, and it is not. Nevertheless, there are some compelling virtues. If matters can be mediated at the beginning of a dispute, a mediated outcome has considerable merit. There is little doubt that the fastest and cheapest way to resolve a dispute if negotiations break down is through mediation. In any partnership agreement that I personally have ever entered into with fellow practitioners or businessmen, I've insisted on the inclusion of a mediation clause. Resort to court is last resort. There's also the perceived benefit of confidentiality. If a matter can be resolved by mediation, the disputants can keep their issues of discontent in-house. If there's any dirty linen, it's washed in-house, never in public. For people in high office, this is most important. Reputations, particularly in this day of age where communications via the internet are immediate and widespread, mean that anything odorous can be seized upon and published very quickly. Furthermore, once the odium is out there, it can never be archived, placed in a vault that's ordinarily dedicated to the scurrilous. Information that's published on the web remains there in perpetuity for all and sundry. The need for confidential resolution of disputes is therefore greater than ever, and mediation is a useful, although not necessarily perfect, way of achieving this. There are, however, some who are not convinced of the benefit of mediation in terms of confidentiality, and I'll quote from Field, Rachel and Wood, Confidentiality, an Ethical Dilemma from Marketing Mediation, where it's stated, it could be said that the reality of confidentiality in mediation is large part reliant on the goodwill of the parties. If goodwill breaks down, then somewhat ironically, whether confidentiality will be upheld or not depends on a relatively insecure set of legal protection. From an ethical marketing perspective, it's less than desirous to use the concept of confidentiality to promote mediation, certainly not without providing full information about the qualified nature of the concept and practice. Indeed, the accuracy and legitimacy of some of the assertions made about confidentiality and mediation can be brought into serious question. I mean, think of a mediation, you go all day. In many instances, both parties present their case. There'll be thousands of words enunciated during the day, a lot of information exchanged, and either party will get a fairly good insight into the respective strengths or lack of in a particular case. Yet there's this cloak of confidentiality. But how can one quarantine the information? How can one quarantine it? The fact of the matter is both parties, everybody at that table will have learnt a hell of a lot more about the other side's case, the nuances and the subtleties as a result of that day at mediation in circumstances where the mediation fails. So I agree with the authors that there is a bit of a misconception about the idea of confidentiality and mediation. As one of the perceived benefits of mediation is confidentiality, yet in actual practice, as the said authors contend, this may be an assumption in some instances rather than a fact. Settlement condition belts and braces should be brought to bear to secure confidentiality, where settlement via mediation is engineered through settlement agreement. There should be a confidentiality clause, and there also should be a provision potentially that any breach of that confidentiality stipulation with regards to material that is incorporated into the settlement agreement is actionable at law, constituted as a breach of the agreement and actionable. So note, although it might be very, very difficult to attach the cloak of confidentiality to things that are said during a mediation, once an agreement crystallises in writing, then if there's a confidentiality agreement, then one can definitely have a provision that respects the integrity of that which is in the agreement. One can't assume that everybody going into mediation is going to be there in good faith. There might be a party that attends a mediation if for no other reason that the party is compelled by the court to attend a mediation. And at that mediation, the party might be using it as a fishing exercise, might be testing out the strength and weaknesses of the other side's case, might be getting an idea of how capable or lacking in capability the advocates are, might form a view that, well, I've seen the advocates in action and I've seen the emotional, a volatile opponent. I prefer to just bide my time and do them over in court. So do not discount the possibility that there might be a party at a mediation who is disingenuous and is using the whole exercise as an information gathering scenario. Now, and also withstand the pressure of mediators intent on forcing a settlement at mediation, notwithstanding the fact that you've got an outstanding case that does not lend itself to compromise. A typical parlance of a mediator will be there's no guarantees in a court of law, which is a statement of fact. It costs a fortune and it's attended with risk. Yet there are situations where one has an outstanding case, where one might want to compromise to the tune of 1 red cent. And the other side, if they're not enamoured with the notion of providing an attractive offer, then one should be ill-disposed to settling. One caveat, one has to assure that the opponent has money in the bank to pay for the determination if there's ultimately a court award on point. I remember one case years ago where I went to mediation. I wasn't in the least bit inclined to settle at the mediation because I'd formed a view of the fact that the opposing counsel in the fullness of time could be worked over with the right pick. And we had a junior barrister, but on day one of the trial, I brought out a QC. The other side's barrister, who was capable, nevertheless lost his composure on the day because he was terrified of the QC and assumed that the QC would be retained to run the balance of the 3-week trial. And settlement was augmented in very, very good fashion for our client. Now, if we had settled at mediation, we would not have been able to get as good an outcome as we did by virtue of a day one of hearing settlement that occurred after hours. So in terms of an advocate, mediation is a tool, but I go back to the original premise. It's not a dispute resolution panacea. Another advantage of mediation is the parties have got control. When a matter goes to hearing, the parties do not have control. The control is migrated to the judge or the decision maker. And that party has all of the control, all of the power. So whilst a mediation is on foot, a given party can decide whether he or she or it wants to settle. So each party at the mediation has the power to settle. So each party at the mediation is invested with the ability to control their own destiny. If the mediation fails, then the adversarial ante is upped, and to reiterate, the control or dictate your own destiny that facility is lost. Just by way of reiteration, never ever settle at mediation if you've got a very strong case and the other side do not have a strong case and the other side has the ability to pay a judgment. It's akin to gunboat diplomacy. If you've got the gunboat, then use the guns. Never hide them. It's also akin to like a heavyweight boxer, reminiscent of someone like Mike Tyson. In his prime, as a pugilist, when he was about to knock a man out, he didn't stand back, give the person time to regain their composure. He flattened the opponent. And when one has that sort of power as a disputant, because one's got a great case and one's in the right and the opponent has a poor case, then don't hand out cups of tea. Go away and knock them out. Now, shortcomings. I've expounded some of the virtues of mediation, and I've explained that personally I find it as a critical element in the dispute resolution repertoire. As I've always ensured in any partnership agreement that I've ever entered into, that there's a mediation clause. It speaks volumes as regards the confidence I have in mediation as being a mechanism to facilitate a negotiated outcome with a minimum of external disquiet. It's critical, if one wants to achieve an outcome of mediation, that one is prepared to entertain compromise. That is assuming that one doesn't have a bulletproof case or set of scenarios. And compromise is never much fun. But if the mediation fails and the matter has to go to the courts, it's going to be very expensive. It's going to brutalise whatever was left of a relationship. It can take months, if not years, to resolve. And it's going to be high profile and it's going to be very public. But it does have its imperfections as a dispute resolution system. Firstly, there's a lack of accountability. Judges invariably are preeminent advocates before they get onto the bench. They've all got law degrees. They've all had many years of experience perfecting their craft. They've got a very, very high judicial rigour. Arbitrators, likewise, have years of experience and have a qualification rigour complementing that experience. Mediators, depending on the course, you can be tooled up as a mediator in a day or so. The course that I did was a 3-day course years ago. Ironically, I don't know if I learnt any more in the 3-day course than I'm expounding in over this particular hour. And it's troubling that there are no formal qualifications for mediations, and it's trouble that there's no regulated, legislated set of ethical or compliance criteria for mediators. If a judge makes a mistake, it can be appealed to a court of higher jurisdiction. If a mediator has been overly interventionist in engineering a settlement, and the settlement is fraught with prejudice attaching to a particular party, there's no appeal right. So there's no accountability. Although by and large mediators have some training, when one considers the extraordinary persuasive power that they may have, albeit by cajolement, charisma. It's troubling that there are not more robust and rigorous mediation training courses. Anyone who has a prominent office in the dispute resolution chain, in my view, should be very well trained in their craft and in possession of a very serious rigour. The rigour should go beyond being a settlement scalp hunter. And by that I mean I have anecdotally come across situations in certain jurisdictions where it's come to my attention that mediators have boasted about how many settlement scalps they've acquired in a given year. There are no comprehensive or uniform standards applied to mediators in Australia. While it may be undesirable to impose a unitary standard of training and accreditation on the diverse forms of mediation practice, there are some strong arguments to support a unified approach to legal regulation and mediation practice in its diverse forms across Australia. Now, that quote comes from Robin Carroll on mediator immunity in Australia, Sydney Law Review. So, Ms. Carroll is correct. There is no uniform rigour governing their practices. Ms. Carroll also talks further about immunity of mediators, and she's got a couple of useful quotes. And Babette Walsky, an associate professor at Bond University and a mediator, states the influence a mediator can have. In our culture today, entry into and participation in mediation may not be voluntary. In practice, mediators exert pressure to settle, and they influence outcome. They are neither completely neutral nor impartial. The assumption that mediators are or should be mere catalysts, or that they are and should be impartial or neutral, is not founded on careful and detailed examination of the actual roles and behaviour of mediators. Now, just a comment. We're lucky to have Stephen Smith here, a barrister of 23 years standing before he became managing partner of Lovegrove Solicitors. He's always got a flat-out schedule in courts, but he was able to attend the seminar. I'm interested in Mr. Smith's views on whether he thinks mediators exert pressure to settle and to influence outcome.
Thank you, Professor Lovegrove. My experience in relation to mediators is that they all do have their own individual style and idiosyncrasies. I don't think that necessarily connotes that I've found there to be some prevailing level of bias or favouritism. There are varying degrees, and some mediators will be overly forceful to work on parties to get maximum leverage to procure a settlement. The question becomes one of whether they are using that degree of influence that it becomes what may be called undue influence. This is something that parties themselves and their legal practitioners have to monitor and ensure that that doesn't occur. At the end of the day, one has to remember that a mediation can only be resolved by agreement where all the parties of their own free will consent. Thank you, Professor.
I've also had a fair bit of experience with mediators, primarily in VCAT, but also with members who are acting as mediators in compulsory conferences at VCAT, but also some private mediators who are ordered to or arranged from a referral from, say, the county court. I find that the private mediators have been very good. I think a good mediator is one that is personable, possibly even uses humour at the right times, develops a good rapport with each party, but is unafraid to dish out some home truths to each party in private as to the weaknesses of their case, and also to help develop some form of compromise by possibly giving an indication as to what a likely outcome would be if the matter was to go to a final hearing. I have found there to be in different qualities of or should I say variable quality of mediators in VCAT. As Mr. Smith said, some can be too activistic to try and get a settlement. Sometimes there's been even examples of an offer being put which may be a few $1,000s higher than what one of the parties was prepared to offer without an imprimatur being given for such an offer, which is not good conduct by any stretch of the imagination. And at the other extreme, there's been some mediators who have basically shown disinterest in what is going on around them. Now, that's a minority. Generally speaking, the mediators have been of fairly good quality. The members are almost always obviously of good quality with the mediations. But again, it holds true that a good mediator is one that takes the case seriously, is not completely directed towards a settled outcome, although that's the primary outcome, but also gives some indication to the parties as to where the case may travel if it was to continue to be contested. And it's often true also that at the conclusion of a mediation there is no one party that walks away happy, because it always involves compromise.
I concur with my learned friends and colleagues' comments, and I don't concur with the aforementioned author's views that mediators endeavour to impart some sort of ideological nuance to an outcome. I've always found them to be impartial, but I have to say that it has not been an infrequent occurrence to come across mediators that are far too forceful in driving an outcome. And the advocate and the disputant must ensure that they are not terrified into settlement by virtue of the mediator portraying only a worst case scenario. Typically, mediators will say, if the matter doesn't settle today, and if the matter goes to trial, it's going to cost a fortune. And there are no guarantees. And I've come across situations where mediators have only focused on the worst case scenario. In fact, I haven't come across too many situations where a mediator has had provided a balanced sermon, i.e., if you go to trial and you win, you'll get the majority of the cost back. And if you've got a very, very strong case, then one has to think carefully about settling, particularly if the offer isn't suitable. Mediators don't normally talk about best case scenarios. They don't normally talk about a situation where a very, very robust case in some circumstances can lead to full indemnity costs. So there seems to be a waiting for dwelling on the worst case scenario. And dwelling on the worst case scenario brings to bear tremendous pressure upon a given disputant, and the lawyer, the advocate representing the given disputant, must ensure that he or she is sufficiently resilient and robust not to allow a forceful mediator to drive an outcome. And I can recall one situation on point. There was a mediator who was adopting a fairly robust approach to settlement and trying to steer my side down a course that would have culminated in serious compromise to my client. The facts were that there was encouragement that my client enter into a 2-year arrangement whereby he would be drip-fed the amount of money that was owed to him. And yet, on the other side, there was a $2 company. So at any given stage, the other side could have aborted the payment. At any time, the other side could have aborted the instalment plan, whereupon my client would have been left not destitute, but in a seriously compromised position. And I fairly assertively communicated my reservations about this particular settlement scenario. And the mediator got quite obstreperous, was most disappointed. And I remember saying, quote, "If I accede to this direction that you're steering us towards, then I may as well ring the Solicitors Liability Committee right now and notify them of a circumstance that may give rise to a claim, because if I accede to the proposal that you're putting to us, then I will indeed be committing an act of negligence." The thing to take note of, however, a junior lawyer may not have been sufficiently robust to be resilient to a very assertive, domineering mediator in pushing a course of action. To be frank, the mediator should never have pushed any type of course of action. But when I referred to the settlement scalp hunter, that was the sort of character I'm talking about. Mediators must be impartial. They can cajole, but it is not up to them to talk about the respective strengths and weaknesses of a given case, because it is not up to them to provide a legal opinion or a decision on possible outcome. One vexed question is whether indeed mediators can be sued. I've touched upon this earlier on, and I have not been able to find any case where a mediator has been sued for, I suppose, problematic procedure. The difficulty in suing mediators is probably because mediation is a new addition to the dispute resolution repertoire, somewhat of a dark and evolving art. As canvassed, mediators are not supposed to make decisions, and although a mediator never makes a decision, the errant mediator making a recommendation or proffering opinion that affects a settlement is influencing the decision to settle. If the decision is settled and compromised on the basis of a misconceived mediator's expressed inclination, the conduct of the mediator should, in my view, be actionable at law. The difficulty is if one's intent on suing a mediator, what is the basis of action? The duty of the mediator is not codified or regulated. It's pretty ill-defined and speculative. As some mediators are not remunerated by the parties, does their duty to the party differ to circumstances where the mediator is remunerated by the parties? Interestingly, the Australian Capital Territory, one of the jurisdictions in Australia, proclaimed a Mediation Act in 1997, and this act affords mediators an immunity of sorts, in that Section 12 provides that a mediator has, in the exercise of good faith of his or her functions as a mediator, the same immunity as a judge of the Supreme Court. It's probably a fairly loose immunity, because the types of mediators that I've been talking about who try and push an outcome, drive an outcome, well, really they are breaking free of their mandate, their mediatory mandate, and the leash. So it could be argued, if there's any attempt by a mediator to force an outcome, that that's not good faith. Unlike lawyers who are required to enter into cost agreements with their clients that are regulated by Solicitor Conduct Acts, mediators do not explicitly contract with clients to dispense impartiality, ethical reverence or detachment. So in the absence of any contractual obligation, one to sue a mediator, one would have to imply certain duties that are somewhat misty, ill-defined and opaque. Our duties as lawyers are clear. They're codified in statute. Mediators' duties are not, and yet they are, in many instances, very powerful dispute resolution actors. So I think it's, in theory, possible to sue a mediator for errant practice as a mediator, but it's been very, very difficult to find a case where a mediator has been taken to trial and found guilty, so to speak. I'm not even sure if there's any professional indemnity cover that provides indemnification for negligent conduct on the part of a mediator. And a further caution to advocates, be they lawyers or be they any other type of advocate. The advocate must be very vigilant and bold if need be in ensuring that a bad deal that is put to the client is described in no uncertain terms, lest the lawyer be implicated in a questionable outcome. The last thing the lawyer would want to be is a client's safety net for a compromise settlement in circumstances where a forceful or vociferous mediator extolled the virtues of settlement and the lawyer meekly acquiesced or endorsed in that facilitation. For to do so could mean that the lawyer would be sued for a failure to emphatically reject the mediator's recommended course of action. Now, a couple of final things before there's just some general discussion where I'll be seeking some further views and inputs from Mr. Stephen Smith and Mr. Justin Cotton. As regards costs, mediators can cost anywhere between $1,500 and $10,000 a day, depending on the level of seniority or juniority. And it's money well spent if a mediation facilitates settlement by the end of the day. Note that in our experience, mediations often go on for a good many hours, sometimes well into the night, and one should be prepared to go the distance. Another caveat, however, often a long, tortuous mediation that goes on into the night culminates in a situation where terms of settlement are prepared when the parties are somewhat exhausted. And equally often, mediators are often determined to get the matter settled that night so that a bird in the hand is worth two in the bush. That is the most dangerous phase of mediation, when the settlement agreement is being written up and engineered. The devil is most definitely in the detail, and one should not settle a matter merely because a mediator wants to get the matter settled that night so that he doesn't have to come in the following morning, if rushing into the final wording culminates in a material mistake. Because the material mistake can be highly prejudicial to an unsuspecting party. As regards time, I've touched upon that. A mediation will normally take a day or so, but if the parties are getting traction and they can't resolve a matter in a given day, then there should be agreement for the mediation to be part heard, so that the momentum of goodwill can generate a positive dividend. From a commercial impactor point of view, of course, a mediated outcome is far superior to a court outcome, because the parties are able to conclude matters within the context of them being in control. They're not migrating the destiny of the dispute to a third party, being a judge, who in many respects is a total stranger to them. That concludes the presentation, but it'd be most valuable to have some words of wisdom from Mr. Smith, Mr. Cotton, also Mr. Cayley Lovell, who is a special counsel at Lovegrove Solicitors, a solicitor of many years standing. So if we can just open it to the floor, starting with you, Mr. Cotton, what are some of the other things you might want to opine?
Yes, thank you, Professor Lovegrove. Just noting down some thoughts. Just echo what my colleague, Mr. Smith, said about. I also believe that an early mediation is a good dispute resolution mechanism, and the earlier it is, the better it is. Bearing in mind that at mediations, it's very rare that any party is ever going to agree to pay anything towards the other party's costs. So what you're really settling at a mediation is the principal dispute. As a matter of principle, parties generally do not wish to pay any cost towards another party. So if you're incorporating in your offers at mediation anything to do with costs, it generally has to be disguised as some form of global figure that you're bargaining over. Echo also what Mr. Smith said about mediation agreements. Also already at the outset do protect not only confidentiality of parties, but also the mediators themselves in relation to setting out that they cannot be sued for negligence. They're only really liable for actions done dishonestly as a mediator, or with a lack of good faith, or with reckless disregard. I have had a matter, as Professor Lovegrove mentioned earlier, in relation to before a mediation even got off the ground, which was to take place next week. The other party dropped their lawyer for whatever reason and is now saying they're happy to do mediation but won't pay any of the costs. As a result, the mediation is going to fall over because the general convention is that parties to a mediation bear the cost 50-50, including the mediator's costs and any room hireage costs. Sometimes mediators do place too much stress on the costs going forward to try and effectively scare parties into a settlement. It's good to have a robust mediator, but some of them do step over the mark of being too robust at the expense of, the questions of justice between the parties. So sometimes stress should also be placed when you're trying to persuade parties towards settlement on other factors such as stress going forward, time, and of course cost. Cost is one factor, and a good lawyer will always explain to their client costs going forward on the eve of a mediation and during the process itself on the day. I think there is an obsession sometimes with long mediations that there must be terms of settlement drawn up on the day. I echo that as probably, as Professor Lovegrove said, one of the most important aspects and dangerous aspects of the day is ensuring there are no pitfalls or traps in terms of settlement, unintentional or otherwise. So a part-heard mediation is still good because the parties have invariably made good progress towards a settlement. Sometimes you might need to have a recipe of defect items which have to be resolved and possibly signed off, and there may be time for the parties to agree on rather complex terms of settlement. I don't believe that's necessarily going to mean the whole mediation falls over. I think as long as the parties keep up a full head of steam on working on these aspects, then invariably a settlement will result from such a mediation.
Look, mediation is one of the greatest dispute resolution mechanisms there are, and that's particularly so having regard to the cost that one can get a settlement relatively to what the cost may be if one has to engage in lengthy litigation. So I would certainly encourage legal practitioners and their clients to engage in mediation at their earliest opportunity, mindful of the fact that the longer one leaves it, the more the costs are going to go on or escalate in any sort of dispute. And the more the costs have escalated, the more difficult it becomes to reach a settlement that's going to be achievable and palatable to some extent by all the parties. In respect of what's been indicated by way of confidentiality, these days mediators regularly ask the parties to execute a mediation agreement before the mediation commences on the day, and that has confidentiality terms that can provide a level of comfort that whatever's been said in the mediation, whether it settles or it doesn't, isn't going to be broadcast in public. Finally, just remember that mediators are there to facilitate the mediation. At the end of the day, they don't really care whether you or your client or the other party gets $1 or $1 million. So just take that on board when they proffer to say you've got difficulties or you're not going to win or you should accept this, it's a very good offer, that sort of thing. Always back your own judgment at the end of the day, because after you sign the settlement, you have to live with that. The mediator goes on to the next case the following day. So on that basis, I'd say mediation is a great dispute resolution forum. I would encourage it, but certainly be aware of all the aspects of it so that you facilitate a result, whether you settle or not, that you're happy with at the end of the day. Thank you.